Right now, thousands of people living legally in the UK are walking toward a visa refusal. Not because they broke a rule, not because they did anything wrong, but because the rules changed and nobody told them. They are still planning their future based on information that no longer exists. If you hold a UK visa, if you are in the middle of an application, or if you are working toward permanent settlement, the next 10 minutes could protect everything you have worked for. This is global immigration news, and this is your complete, up-to-date breakdown of UK immigration rule changes in 2026. To understand why these changes matter so deeply, you need to understand the environment in which they are happening. The United Kingdom is operating under sustained political pressure to reduce net migration. That pressure does not stay in Parliament. It moves directly into policy. And when immigration policy tightens under political pressure, it rarely announces itself loudly. Thresholds rise quietly, requirements sharpen, eligibility windows narrow, and the people most affected are not the ones who are trying to break the system. They are the ones who are simply not watching closely enough. Since Brexit, the UK has been building a points-based immigration system designed to standardise how migrants from every country are assessed. In theory, it is a clear and merit-based framework. In practice, it is a system that requires constant attention. Because it is not static, it is updated, it is adjusted. And in 2026, several of those adjustments are significant enough to change outcomes for people who thought their immigration path was already settled. What we are covering today touches 5 major categories: skilled worker visas, graduate visas, family visas, English language requirements, and the indefinite leave to remain pathway. Each one has specific changes, each one has specific risks, and for each one, there is a clear mistake pattern already affecting real applicants across the UK right now. Let us go through each one carefully. Let us begin with the skilled worker visa, because this is where the most consequential and most avoidable mistake is happening at scale. The UK Home Office raised the general salary threshold for skilled worker visa applicants to $38,700 per year. That number is not new to most people following immigration news. What is not widely understood, and what is causing real refusals right now, is how that threshold is actually measured. Most sponsored workers look at their total compensation, their base pay, their bonuses, their overtime, their shift differentials. They add everything together, reach $38,700 or above, and assume they qualify. They do not qualify. The Home Office counts only your guaranteed basic salary. If any portion of your income is conditional, performance-based or variable in any way, it is excluded from the calculation entirely. This means a worker earning $41,000 in total annual compensation, but only $36,000 in guaranteed base salary, does not meet the threshold. Their renewal gets refused, and for many of those workers, that refusal comes as a complete surprise, because nobody explained this distinction clearly when they first received their visa. If you are currently on a skilled worker visa, the action item here is immediate. Do not look at your payslip, look at your employment contract. Find the section that defines your fixed, guaranteed annual salary. Compare that single number, not your total earnings, that single number, against the current threshold for your specific occupation code, because certain roles, particularly in healthcare and education, operate under different thresholds. Your occupation code determines your specific requirement. And if that guaranteed number falls short of the threshold, do not wait for your renewal window. That conversation with your employer needs to happen now. Salary adjustments require time for internal approvals, payroll changes, and updated contract documentation. If you wait until your renewal window opens, you will not have enough time to fix it. Now let us talk about a group carrying a particular and underappreciated level of risk in 2026. International graduates who completed a degree in the UK and transitioned onto the graduate visa. The graduate visa provides 2 years of post-study work authorization, 3 years for doctoral graduates. When students receive this visa, it feels like an arrival, time to work, to explore, to build a future in the country where they studied. What it actually is, and what many graduate visa holders do not fully understand until it is almost too late, is a one-time, non-renewable bridge. When your graduate visa reaches its expiry date, you cannot extend it. You cannot renew it. There is no second graduate visa. The only substantial onward route to continued legal residence in the UK is the skilled worker visa. And to qualify for the skilled worker visa, you need three things simultaneously: a UK employer who holds a valid sponsorship license, a role that meets the eligibility criteria, and a guaranteed salary at or above $38,700. For graduates entering fields like communications, creative industries, early career technology roles, or hospitality management, reaching that salary threshold within a 2-year window is a genuine challenge. Entry-level and junior roles in many sectors simply do not pay at that level, and the clock on your graduate visa started running from the day your degree was conferred, not from the day you started job hunting. If you are on a graduate visa right now, you need to know your exact expiry date. You need to be actively mapping which employers in your target field hold a current skilled worker sponsorship license. That information is publicly available on the official UK government sponsor register. And you need to be honest with yourself about whether the roles you are pursuing will meet the salary requirement before your visa expires. Hope is not a visa extension. Planning is. There is a second element here that affects students still deciding whether to study in the UK. The restriction on bringing dependents on a student visa, introduced in 2024, remains fully in effect in 2026. With very limited exceptions for government-sponsored scholars and postgraduate research students, international students cannot bring their spouse or children to the UK as dependents. This is not a policy under review. It is the current settled position. If your family circumstances make dependent rights a necessary part of your plan, that reality must factor into your decision before you apply, not after you arrive. Of everything we are covering in this video, what comes next carries the most direct human weight, because this is not about occupation codes or threshold calculations. This is about families, about couples, about children, about people sleeping in different countries from the person they love. To sponsor a non-UK spouse or partner to join you in the United Kingdom, the sponsoring partner, the person already living in the UK, must now demonstrate a minimum annual income of $29,000. That figure replaced the previous $18,600 threshold, and it is not the final number. The UK government has confirmed that this threshold will continue rising, ultimately reaching $38,700, placing family visa income requirements at the same level as the skilled worker salary floor. For British citizens and settled residents working in retail, care work, teaching support, early years childcare, or frontline public services, this is not an inconvenient bar to clear. For many of them, it is a wall, and the policy justification, preventing sponsored family members from accessing public funds, does not soften its impact on the thousands of real families separated by it right now. If you are preparing a family visa application, documentation is everything. The income you declare must be verifiable, consistent, and clearly presented. Payslips covering at least 6 months. Your employment contract showing guaranteed annual salary. Bank statements that reflect regular, consistent income deposits. If you have additional qualifying income sources, those must be documented separately, clearly labeled, and submitted alongside your primary income evidence. There is one critical point to understand about this application. Getting the income calculation wrong, misreading what counts, omitting required evidence, or presenting income sources that do not qualify does not simply result in a refusal that you can immediately reapply from. A refused family visa application creates a record. That record can complicate future applications. The Home Office assessor reviewing your file can only evaluate what is in front of them. Assume nothing is self-evident. Document every qualifying element as if it needs to be explained to someone who knows nothing about your situation, because in a real sense, it does. English language requirements have been tightened across multiple UK immigration categories, and in 2026, those elevated standards are the operative baseline. This section is brief, but the mistake it describes is not a small one. For skilled worker visa applicants, English proficiency must be demonstrated through one of 3 routes: a secure English language test from an approved provider, a degree that was taught and assessed in English, or nationality from a country on the UK government's designated majority English-speaking list. The most dangerous word in that first option is approved. The UK Visas and Immigration Approved Provider list is specific. It does not include every internationally recognised English language test. If your test was administered by a provider that is not on that approved list, your application will be refused, regardless of your score, regardless of your preparation, regardless of how fluent you are. The provider must be approved. Verify that directly on the official UK government website before you book any test. For family visa applicants, the English language requirement now applies at multiple points in the process, at the time of initial application, and again at the point of settlement. Demonstrating proficiency once is not sufficient. The expectation is that language ability is being developed and can be evidenced progressively across the immigration journey. Verify your provider before you pay. Verify your qualification before you submit. This is a 10-minute check that prevents an entirely avoidable refusal. Now we come to the section of this video most relevant to people who have been in the UK for years, people who have invested the most, built the most, and who are now approaching eligibility for indefinite leave to remain. ILR is permanent settlement. It is the point at which you can live and work in the UK without a visa expiry date shaping every decision you make. But the path to ILR contains one requirement that is catching long-term residents off guard more consistently than any other: the absence rule. During your qualifying period, typically 5 years, you are permitted to be absent from the UK for no more than 180 days in any single 12-month rolling period. Not across the full 5 years. In any individual 12-month window, this distinction matters enormously. You could have minimal absences in 4 of your 5 qualifying years and still fail the requirement if a single 12-month period contains absences totaling more than 180 days. What makes this dangerous is not the rule itself. It is the fact that most people are not tracking it in real time. They travel for work. They return home for family emergencies. They take extended holidays. Each trip, considered individually, seems manageable. But when the total is calculated across a specific 12-month window, and the Home Office will calculate it, the number can exceed 180 days without the applicant ever having realised they were approaching the limit. The Home Office does not send warnings. There is no system alert, no notification, no flag on your file that tells you when you are getting close. The responsibility for tracking this is entirely yours. And discovering the problem at the point of application, after 5 years of residence, after everything you have invested, is a situation that is very difficult to recover from quickly. Here is the practical step. If you are approaching ILR eligibility, submit a subject access request to the UK Border Force to obtain your official travel history record. This is the same data the Home Office will use when reviewing your application. Audit it yourself, 12 months at a time, across your full qualifying period. If you identify a period where your absences are approaching or exceeding 180 days, begin documenting any exceptional circumstances immediately. Because in limited cases, compelling or compassionate reasons can be considered, but they must be proactively documented, not explained after the fact. Your ILR application also requires passing the Life in the UK test and evidencing a valid English language qualification. If you satisfied the language requirement at an earlier visa stage, verify that the qualification you used is still accepted for ILR purposes. Some qualifications carry time limits. Finding out that your qualification has expired after your application is already submitted is an outcome that proper advanced preparation can prevent entirely. Begin your ILR preparation 6 months before you become eligible. Not 2 months, not 6 weeks, 6 months. The documentation required, continuous residence evidence, employment history, tax records, travel records, language certificates, represents a substantial administrative undertaking. Give yourself the time to do it properly. Let us be clear and direct about who is most exposed under these 2026 changes. Skilled worker visa holders whose guaranteed base salary falls below $38,700, even if their total compensation exceeds it, are facing renewal refusals they have not prepared for. International graduate visa holders who assumed their post-study bridge would lead naturally to long-term residence are discovering the true requirements only as their clock runs out. Families separated by the income threshold for spousal sponsorship are watching that threshold rise while their qualifying income has not, and long-term residents approaching ILR eligibility are submitting applications without ever having reviewed the absence records that will determine whether those applications succeed. What connects all of these groups is not negligence, it is the gap between old information and current reality. Immigration rules do not come with personal notification systems, they change, and the responsibility for knowing they changed belongs entirely to the applicant. The following is general awareness guidance only, not legal advice. For advice specific to your personal situation, always consult a qualified UK immigration solicitor or an advisor registered with the Office of the Immigration Services Commissioner. Every UK visa holder should know their exact visa expiry date, not approximately. Exactly. Set a calendar reminder 6 months before that date and begin your preparation from that point. If you are a skilled worker visa holder, review your employment contract today and isolate your guaranteed base salary. If that number does not meet the current threshold for your occupation code, speak with your employer now. If you are on a graduate visa, build a realistic transition timeline. Identify which employers in your target field hold a current sponsorship license. Understand the salary levels those employers offer for roles you are qualified for. Make decisions based on that reality, not on assumptions. If you are preparing a family visa application, begin assembling your income documentation file immediately. Keep it current. Ensure every income source you intend to declare is supported by clear, consistent documentary evidence. If you are approaching ILR eligibility, request your travel history now and audit it carefully. Organize your documentation with enough lead time to identify and address anything that requires attention before your application window opens. Across every category and every stage, verify everything against the current official UK government website. Immigration policy updates do not always generate headlines. Check directly. Check often. 4 things to carry forward from everything covered in this video. The skilled worker salary threshold of $38,700 applies exclusively to guaranteed base salary. Variable pay, bonuses, and allowances do not count. Know your guaranteed number before your renewal date arrives. The graduate visa is a single-use, non-renewable bridge. The only sustainable onward route is the skilled worker visa, which requires meeting full eligibility criteria, including the salary threshold. Plan for that transition from day one. The family visa income requirement stands at $29,000 and is continuing to rise. Every income source you declare must be supported by clear, complete, and consistent documentation. Presentation matters as much as the numbers. If you are working toward ILR, your absence record is under review whether you are tracking it or not. Request your travel history now. Audit it now. Prepare your full application package no less than 6 months before your eligibility date. The UK immigration system in 2026 does not reward assumption. It rewards preparation. The applicants who succeed are the ones who treat their immigration status as an active, ongoing responsibility, not a background concern they will address when it becomes urgent. At Global Immigration News, our commitment is to ensure you always have accurate, current, and practical immigration information, delivered clearly, without confusion, and without delay. If this video gave you clarity, subscribe to our channel now. We publish immigration updates every week across UK and US immigration systems, and staying subscribed is one of the most practical steps you can take to protect your immigration future. In our next video, we are covering the UK Electronic Travel Authorization, what it is, who it affects, and what it means specifically for visa holders who travel internationally. If you enter or re-enter the UK on any visa category, that video is directly relevant to you. Stay subscribed, stay informed, and take your immigration future one verified step at a time.